Hello guys, this is Samuel Odhiambo, who is a senior law student at JKUAT, Karen Campus, Nairobi, Kenya. I would hereby once again like to take this opportunity to welcome you all to the Samuel Law Podcasts and Academy YouTube practice so that together we can learn more about our laws. Welcome, please. So today we are going to look at our module 4 of lesson 4, where we are going to concentrate on another element of contract law, and that is intention to create legal relations. Welcome. So our objective today is, after studying this module, you will be able to 1. Understand the importance of legal intent in an agreement. Secondly, we shall be able to understand the different broad classifications of contracts in respect to legal relations. And thirdly, we also will be able to learn about the rebuttable presumptions that exist in both social and domestic agreements as well as in commercial agreements. Welcome. So let's begin with our introduction. An intention to create legal relations is an essential ingredient in the formation of a contract, just like offer and acceptance and consideration, as we have already seen in our previous lessons. This is because any agreement made between two or more parties without any intention of being legally bound by it will not be regarded as a contract by the courts, as it will not be legally enforceable. With respect to the intention to create legal relations, contract can be classified into two major categories, and these are 1. Social and domestic agreements, and secondly, commercial agreements. So let's begin with social and domestic agreements. The general presumption in social and domestic agreements is that parties do not intend to create legal relations. But this presumption may, however, be rebutted or overridden by evidence to the contrary, or social changes which may also contribute to such decisions. And the examples here include an agreement between husband and wife. Whenever an agreement is made by a married couple, the law will always assume that they did not intend to be legally bound by it unless there is evidence to the contrary, as was decided in the case of Balfour versus Balfour in the 1919s. Secondly, we have agreements between parent and child. There is a rebuttable presumption that agreements of a domestic nature between parents and children are also not intended to be binding. Thirdly, we have social agreements. The same rebuttable presumption that an agreement is not intended to be legally binding is also applicable to social relations between parties who are not related. Rebutting the presumption in social and domestic agreements. The context in which the agreement was concluded may also lead to a rebuttal. For example, where a husband and wife enter into an agreement to share the ownership or tenancy of the matrimonial home, bank accounts, savings, or other assets. Where the relationship between the parties is approaching a point of breakdown, and where the context in which the agreement is reached is a commercial one. For example, an agreement made in connection with the running of family business. Let's now go to commercial agreements. Contrary to what we've just learned above, there is a strong presumption in commercial agreements that the parties do intend to be legally bound, and unless there is a very clear evidence to the contrary, this presumption cannot be rebutted. This simply means that any agreement made or reached in a commercial context or presumed to have legal intent and therefore legally binding, unless very clear evidence is produced to rebut the same. There are, however, some exceptions to these presumptions, as we are going to see next. Exceptions to the commercial agreement presumption. The presumption that parties to a commercial agreement intend to create legal relations may be rebutted where the words of a contract or an offer suggest the opposite. That is, the legal relations was not intended. This may occur in different situations, which include 1. Mere puffs. Acceptance of any offer which is extremely vague or clearly not intended to be taken seriously will not gain any contractual effect from the law. Second, honor clauses. The effect of such clauses in an agreement is to prevent a contract from coming into existence between the parties. It deters an agreement from amounting into a binding contract. Third, agreement subject to a contract. Whenever these words are used on an agreement, they are usually, but not always, taken to mean that the parties do not intend to be legally bound until formal contracts are exchanged. If the parties subsequently act upon the agreement, their conduct may then be interpreted as amounting to an intention to create the final contract. Ambiguity. Where the words of a commercial agreement are ambiguous and therefore uncertain, the courts will favor the interpretation which suggests that the parties did intend to create legal relations and therefore find that there is a contract, as was the case in Edwards versus Skyways. Collective bargaining agreements. This is yet another exception to the presumption under commercial agreements that parties do intend to be legally bound, as in such agreements, the employer negotiates pay and conditions with the workforce as a whole, that is, trade union, rather than on an individual basis. Collective agreements are conclusively presumed not to be intended to be legally binding unless they are expressly stated otherwise in writing, as noted in the Trade Union and Labor Relations, Consolidated Act of 1992. So, let's, in our conclusion today, intention to create legal relations is indeed a very vital element of a contract. Legal relationship is presumed to be there where there is legal remedy in case of a breach. Generally, social relations and domestic affairs are said to have no legal relationship, as already noted. This therefore means that there is no any legal action that can be taken against the offender in case of breach or violation. And finally, whether or not presumption can or has been rebutted ultimately depends on the facts of the case. Let's have a recap of what we've just learned today. In this module, we've been able to 1. Get the meaning and importance of legal intent in a contract. We've also been able to understand the different broad classifications of contract under creation of legal intention. We've also been able to identify the different presumptions that exist in both social and domestic agreements on one hand and commercial agreements on the other. Fourthly, we've also been able to learn about the rebuttals and exceptions to the presumptions applicable to both social and domestic agreements as well as commercial agreements. Thanks very much for watching, guys, and I hope to see you next in our next module. Thank you. Do you have any questions or comments? Kindly post them in the comment section below the video. Otherwise, thanks for watching this video. Please remember to subscribe to my YouTube